Morning, everyone. Welcome to today's AGP webinar on protecting your business. I know most of you have heard me and my speech, I don't know how many times, but there are a couple that I don't recognize on here. So I'll just go through the ground rules just for now. If you could put your microphone on mute during the presentation, this just avoids any interference or background noise. There will be a question and answer session at the end, so you can come off your microphone then. Switch it back on, or if you prefer, you can pop your questions into the chat facility and we'll go through those with you at the end to make sure that they're getting answered for you. I can see most of your names are quite self-explanatory this morning, so I don't need you to put that into the chat today. If you need any support during the webinar, I'll be here monitoring it, so if you have any problems, please ask. The webinar is being recorded just for collating any questions or comments which may be missed. If you've got any questions or concerns about this, please let us know. As most of you know, following the webinar, you'll be getting some emails from me just to get your signatures to prove to the Welsh Government that you were on the webinar with us this morning and that it actually took place. So I'll be sending those out to you. If you could sign them and get them back to me ASAP, that would be great. Thank you. And then the other email then with the feedback to the webinar as well, which is really helpful to our presenters and for the AGP team to know what to do with future webinars for you. So on that note, I will hand you over to Stephen Thompson. So over to you, Stephen.
Thank you. Morning, everybody. Just to introduce myself, my name's Steve Thompson. I'm a partner at Darwin Gray Solicitors. We're based in Cardiff, and we are an accredited gold partner of the AGP programme. So we've worked with the AGP and with their clients over the years to provide help and advice in relation to a wide range of legal issues. So our kind of main areas, as a commercial law firm, the kind of four main areas of the firm are employment/HR, corporate commercial, which is what I'm predominantly involved in, dispute resolution, and also commercial property. And obviously things are interesting at the moment. We're finding some areas of the business are quite busy and some are less busy. The employment people, not surprisingly, are manic, at least they are at the moment. And the property people as well, bizarrely, on the way into this were so busy, and they remain busy. So that's quite good. We're just trying to sort of help by providing some seminars like this one today, webinars on things that concern the Covid-19 crisis and all the rest of it. So I've got some slides which I'm just going to share with you now. So I'm going to disappear behind the slideshow and take you through those. Let's bring those up. Start the slideshow. Okay. Right. So this is what it is, protecting your business during the COVID-19 crisis. That's kind of what we want to talk about today. Just a few areas which, this is the AGP bit. I don't know whether I'm supposed to talk through this, but that just gives you a little bit of background if you don't already know it about AGP, about the programme and the Accelerator
okay, that was a bit that I was meant to put.
Right, there we are, okay. So there's me, so I've talked about myself. So just the idea there, what I'm going to be talking about, we're going to have a bit of a whistle-stop tour. So we're going to talk about suspending and terminating contracts during the crisis, some supply chain issues, just a couple of points about consumer contracts, some proposed changes to the insolvency regime, and also just a little bit about COVID-19 related insurance claims. But that's kind of the topics that I'm going to run through today. So just start off the blocks with something called force majeure. So I imagine one or two of you have probably come across this concept fairly recently. Force majeure is one of those things where it is a little clause which you'll normally find towards the back of most written contracts. It's a clause that very rarely anybody pays any attention to. It's very, very rarely relevant, because what force majeure is where something happens and because of that a party is unable to perform their obligations under a contract. And it's kind of things like pandemics or wars or strikes or highly inclement weather, that kind of thing. And because it's so rare, nobody really pays much attention to it. But certainly if you have a written contract, in the bit at the back, which has got all the stuff about giving notice and governing law, you will probably find it tucked away. And lawyers generally don't get very excited about it. But it has come to the fore a bit recently, because as you'd imagine, with the crisis, and particularly because it's a global crisis, people have found themselves in a position, businesses have found themselves in a position where they can't actually comply with their contractual obligations, or people they are contracting with can't comply with their contractual obligations. So you may or may not have come across this. And it may be something that you have heard of, certainly in the recent past. So I just want to talk briefly about what it is. So what is force majeure? Well, I've kind of touched on that. The thing with force majeure is there's no common law concept of force majeure. So it only happens, it's only applicable if there's a clause in a contract. It's a contractual thing. So basically, if you don't have a force majeure clause in a contract, then you can't really raise force majeure as a reason why you can't comply with the terms of the contract. So it is a contractually related thing. And if there is a clause in the contract in which, say, either you or a third party can't now comply for various reasons, or mainly because of COVID-19 restrictions, then you might want to try and rely on that. And it really goes down to exactly what that clause says, because there isn't a standard force majeure clause. That you might think there is, because they all look quite similar, but they are all slightly different, and they don't have to be worded in a particular way. So the first thing to do, if you are either thinking of trying to rely on it, or you're faced with somebody else who's trying to rely on it, is to look at what it actually says, because that's crucial. Because it will only be applicable if it's worded a particular way. And the first question is, does it refer to a pandemic? Because most of them actually don't. The short versions, if you just got a little 2 or 3 liner, probably hasn't got any reference to a pandemic. In fact, it may not refer to any specific event. It may just say if there's unforeseen events. So that's the first question. And if it does refer to a pandemic, then that's great, because that's the first box tick. There's a number of hurdles you have to clear, but it may not do it. Just because it doesn't mean that you can't rely on it, or a third party can't rely on it. But it is something that you need to look at very carefully. So the first thing I would say is you probably are going to have to take advice from a lawyer on it, because it is a slightly technical area. And I would say particularly if you're faced with a third party that's trying to use it against you, you probably want to reach for the lawyers fairly soon to get some advice, because it may not be as it seems. So that's the first question. Can you rely on that force majeure clause? Can you rely on it, or can that third party? Because they are very narrowly construed. So the courts will look at the precise meaning of them and not go beyond that. They don't tend to construe them in a particularly wide way. So if you read it and you think, oh well, we might get away with interpreting it in a particular way, well, you might not actually. And the other thing as well is the courts tend to expect specific compliance, careful compliance with the provisions, because quite often they will contain notice provisions, so that if you consider that you are going to be prevented from complying with a particular contract, that you may have to give notice under the clause, and you will have to do that very carefully in compliance with that clause. So you need to check it, and you need to have a look at it and try and work out for yourself what you need to do to be able to comply with the clause. So that's the first thing I would say. As I say, get that advice. But if you do receive notice from the third party, so say you've got a supplier who sends you a notice saying, oh well, we're giving notice pursuant to the force majeure clause because we don't think we can comply with it, so we don't think we can comply with the contract. This is really give you an idea of the kind of things you would need to do if you had that notice. So as opposed to just panicking and blindly thinking, well, what are we going to do, the first thing to do is check, well, does this contract contain a force majeure clause? Because sometimes people talk about force majeure without actually knowing that they've got to have a clause to rely on. So they might just say, oh, well, because of force majeure, we're not going to be able to do X, Y, and Z. Because quite often in this pandemic, as you would appreciate, people are finding that that their contractual obligations are more difficult or more expensive for various reasons, and obviously understandably, if they've got contractual obligations that are a lot more expensive for them and a lot less profitable, they might want to try and get out of those. And if they're waving around force majeure as a reason, as people often do, then that might come to you, and you may need to think about it. So check that there is a clause. You don't have to look at the clause and think, well, has it been triggered? Can they rely on it? Has the wording of the clause been activated so they can rely on it? And again, that might require you to go and speak to a lawyer. And then you need to think, well, have they given the proof of the fact that the COVID-19 crisis means they can't actually comply with the contractual obligations? They can't just say, oh, well, COVID-19 force majeure, sorry, we can't do it anymore. You can't just say that. You've got to establish that because of the COVID-19 restriction, you can't comply, or you can't comply in full. So that's the next thing. And also, as I mentioned earlier, if there are strict procedures set out in the clause, because if you're involved in a contract which is particularly long and got lots of legal stuff in it, then you might find there's a longer form of force majeure clause, and they tend to be the ones that have got the detailed procedures. So you need to check whether that procedure has been followed. And then also think about, well, what relief does that clause provide? Because everything comes out of that clause. So if that clause says the contract is suspended, then that's what's going to happen. Or if it says it's terminated or terminable, then that's what's going to happen. So that's the other thing. And then also think about, is there anything else in the contract which is relevant to that situation? Because I'm going to mention a little bit later on about suspension of contracts. There might be something in the contract that relates to that. So if you get that notice, don't just panic. Don't assume, because it's quite often easy, I think, when you get like a nice letter or an official-looking letter from a party, it's very easy to sort of assume that they're right and that what they say must be right. But actually, a lot of the time, people are just winging it. So you can really think calmly, well, let's have a look at the contract. What does it say? And as I say, I think you probably, if it's a valuable contract and you're not going to be able to sort it out yourself, I think you may well find that you will need to get some legal advice from somebody. So that's sort of force majeure. I mean, it is quite a complicated area, and I think if you do find yourself in a force majeure situation, you probably will need to get some advice, unfortunately. Doing a couple of things to think about are frustration and illegality. You may have heard of the concept of frustration. This is a common law doctrine, as we like to say in the legal profession. The question is, has performance of the contract become legally and physically impossible because of the COVID-19 restrictions? Is it frustrated? Well, the word frustration gets bandied around quite a lot, I find, but actually parties managing to successfully argue that contracts have been frustrated is relatively rare. So it's not, although people talk about a contract being frustrated, it doesn't legally happen that much. An example of when it has happened in the past is the Second World War. So if you had a contract with the enemy, or what was formerly not the enemy, and they became the enemy, then you wouldn't be able to trade with them. So that would definitely have been frustrated. But as I say, it's not as common as you might think, but it is irrelevant. It is something that's relevant in the situation we're currently in. And if the contract has become frustrated, because either you physically and legally can't comply. Well, either you physically can't comply with it, or you legally can't comply because what you have been doing is no longer legal or not currently legal. Then that contract potentially ends automatically and immediately. If it's frustrated, nobody needs to do anything. But unfortunately, there's a very limited redress available to either party. So if a contract you're a party to is frustrated, you will probably find that there'll be not a lot you can do about it. It's just one of those things, unless maybe you have some insurance. And then, as mentioned, illegality. If the contract that you are a party to, the performance of it becomes illegal due to the COVID-19 restrictions, then that in itself may cause a contract to be frustrated. So that's sort of force majeure and frustration, which are two of the main ways in which contracts might come to an end or be suspended legally because of the COVID-19 crisis. And as I say, you may come across that. So just talking about suspension generally, about whether there is actually a right to just suspend contracts. So there isn't a general legal right to suspend a contract just because the other parties failed to perform. Some contracts do contain express rights of suspension, particularly longer contracts with more detailed goods and services quite often contain suspension clauses. So if a party doesn't act in a particular way, then you may have the right to suspend performance under that contract. But that will be in the contract, and you probably will be aware of that because that's the kind of thing that you will have negotiated. Suspension rights don't generally appear in kind of typical T's and C's. So, you know, if you're ordering goods and services on a purchase order and you've got invoices or whatever with T's and C's printed on the back, then there may be something there about suspension, but it tends to be more typical where you've got longer service agreements that people have negotiated and had a proper look at. But do have a look because there might be something there. And also you could always agree something as well with the other party, because obviously everybody wants to try and do the right thing. And I think, you know, everybody's talking now about what it's going to be like when we come out. So you don't necessarily want to burn all the bridges by going all legal on people. And I found, I mean, I get involved in disputes as well, and the number of people, I expected more businesses coming to me saying, you know, they wanted to sort of issue letters. to other parties, but that's not really been happening. My gut feeling is it's more likely to happen when we come out, because that's when there'll be more of a reckoning as to who's been doing what, where, and when. But I think everybody's just surviving at the moment. And then just that final point there, if you did take it upon yourself, if you decided unilaterally, well, I'm just going to suspend performance under this contract because it doesn't suit me anymore, because either it's too difficult or it's expensive and the contract's is less profitable, then you may well, by doing that, if you've not got legal entitlement to do it, be entitling the other party to terminate and claim damages. So you have to be really careful about what you do. And I would always say, if you are agreeing something with another party, make sure it's properly documented as well, because if you just do something loosey-goosey over the phone, then you might find at a later date, when all of a sudden a director of a company decided that you did a deal, decided it doesn't really suit him to have done that deal. He might have forgotten about it. So even if it's just an exchange of emails, it's always worth doing that. So the next point is about abandoning contracts. Can you walk away from them? Just because of the Covid-19 restrictions, because, as I said, it's too expensive to perform or too difficult, then you might be able to. So if you've got a frustration, which, as I say, is quite rare, but it does happen, or if there's force majeure, you might be able to get out of it. But you do need to be careful, because again, if you fail to perform unilaterally, then you just find potentially that you're in breach and they're going to sue you, and you don't really want that. And you've got to be careful, even if you walk away from a contract where you've not yet got any obligations to do something. So say your obligations don't arise for another 6 months, you've agreed to supply some goods or services, but not for another few months. If you walk away from it now, because I've had people saying to me, well, this contract hasn't started yet, has it? So I can just walk away from it. And I'll say, well, no, your obligations haven't started, but you've signed it, so that obligation is there in the future. So you have to be clear about what those obligations are. Just because you're not obliged to do something for 6 months doesn't mean that there isn't a legal obligation there. And if you just walk away from it, you could be setting yourself up for problems down the line. And the last point there as well, just to say, check limitation of liability clauses, because quite often contracts have those in, and they will be important, because if you do walk away from a contract, then the extent of your or a third party's liability will be quite crucial. I mean, typically in properly drafted contracts, there's an exclusion of liability for consequential loss, so loss of profits. But you do need to check those. So if you're planning on making a big move under a contract, again, probably take some advice on it so you don't end up having problems further down the line. And then termination of contracts. Can parties simply terminate a contract? You can do anything you want by agreement, generally. Most contracts will have express termination provisions in them. So some of them will allow you to terminate, as they say, without fault, like a no-fault termination provision on notice. Well, do check those provisions. And also insolvency might be relevant, because if somebody's technically insolvent, then that might be another basis for termination. But you have to be careful about exercising termination rights, because if you rely on what you think is a valid termination right, and it turns out that you shouldn't have relied on it and you didn't have the right to do it, then you yourself are in breach, and the other side's going to be potentially suing you on the boots on the other foot then. So think about force majeure as well, but do avoid wrongful termination, because if you act too soon, then you might find that you're going to have a bit of trouble further down the line. So again, that's something that quite often people come to lawyers with, because there's just risk there if you act without having the right to do it. Well, obviously you can renegotiate terms. Do check the terms of the contract though, because quite often contracts have terms in them about how they're varied, and then most contracts will say that they can only be varied in writing. So do check that and make sure that you're complying with those. Although generally speaking, if there's a contract with two parties and you both agree to do something in a certain way, a court will generally enforce that. But just check that provision and say normally it's no more than in writing, but sometimes they'll say things like got to be signed by a director, stuff like that, because you wouldn't want to agree something and then find out further down the line that just because you didn't get John down the office as a director to approve it in writing, that it's invalid. So do check that. And also think about the knock-on effects in the contract chain. If it's more than two parties, there might be other people involved in the chain. So think about, if you agree something with another party, does that affect anybody else, either up or down the line? So think about those consequences. and also the extent of the changes you're agreeing. Are they time limited? So be very specific. Quite often I see people agree things, but you think, well, you didn't really think it fully through. You know, how long is this agreement for? And you do need to think these things through and the consequences of them. And also third-party interest, whether it affects any lenders, whether there's any security. You know, you might make a change to your business, which might put you in breach of a covenant with a bank or what have you. So you do need to think about the wider picture, and also think about consequential amendments in the contract, because you might amend one bit of it, but it might mean that something else has got to be changed. So it's all a bit annoying and legal, but it's just that unfortunately that's the world we live in. And I think afterwards, my feeling is with the legal bit will be the afters, like further down the line. Because once everybody's feeling a bit more confident and got back in the office, that's the time when, if people haven't done what they should have done, that they might decide that's the time they're going to have a bit of a pop. So just a few thoughts on supply chain. I don't think there's any silver bullets in here, but I mean, just thinking about supply chain and keeping that going, I imagine by now, you know, 5-6 weeks in, those of you that have a supply chain that you're relying on, I imagine you may well have had to already deal with it. So supplier may seek to rely on a force majeure clause or frustration, but I mentioned that earlier. And as I said, you may need to take advice on that. Also, if you are thinking of terminating a supply contract, common sense dictates to make sure you've got somebody somewhere else that can provide that for you. But I mean, that's a fairly obvious point. And then also, it's good to talk, isn't it? So if you know, somebody's thinking of terminating, or you're thinking of terminating, well, maybe consider a variation, because that might be less costly or more convenient for you. So always do have those conversations with other parties, and a temporary suspension might be the way forward. So as I say, there's no silver bullet in there, but I think there's just a few thoughts there just to bear in mind when it comes to dealing with suppliers and how to reconcile any situations that might arise through the current crisis. Just thinking about consumer contracts, there's a slightly different ball game with consumer contracts, because with business contracts, B2B, you can pretty much, subject to certain broad restrictions, you can pretty much agree what you want with another business. I mean, there are sort of reasonable tests with things, but the courts tend to work on the basis that, well, if one business wants to agree something with another business, that's up to them. And just because you've made what you later consider was a bad deal doesn't mean that the court's not going to enforce it. So you have to be very careful. Well, obviously, with those of you that are in the consumer market, it's very different. So, for instance, traders, I've used the term traders, but it's basically anybody supplying to consumers, will know that their ability to exclude or limit their liability is strictly controlled by statute. I'm not going to go into that now; it's beyond the scope of today. But it's a tricky area, and there's lots of consumer legislation which provides for lots of protection for consumers. And you can't, if you're a supplier of consumers, you can't prevent a consumer from exercising their statutory rights. And the third point there, any contract terms which are seeking to exclude liability for delay are generally likely to be considered to be acceptable in those circumstances. So where the delay is beyond the reasonable control of the trader, or where the trader takes reasonable steps to prevent or minimise the delay, or if it's substantial, then the delay may cancel without any penalty. So I think businesses that supply to consumers are in a different situation. They are governed by much more stringent rules, and therefore the options open to them are sort of more limited. And then in terms of that, if you are dealing with consumers, just a few ideas as to how you might want to sort of manage the risks of late delivery or performance. There's a few ideas there. So you might want to provide that delivery or performance is within a date range as opposed to on a particular date. And I think, to be fair, I think these ideas are equally applicable to B2B contracts. So, you know, if you're entering into contracts now with other businesses, you might want to think about these things, because you don't want to overcommit yourself. You don't want to maybe act in the way that you would have acted before this, because this is going to go on for a while, and you want to give yourself a bit more wriggle room. And the second point there, if you're going to change delivery or performance dates, do it with the customer's agreement or with the other side's agreement. And then maybe reschedule where delivery or performance isn't sort of an essential item. I think that becomes a bit more tricky with consumers, obviously, if you're dealing with them and it's an essential item, it's a bit more tricky. But then what they do have, as I mentioned earlier, is a sort of raft of protections in relation to cancellation rights, that kind of thing. And I guess when you're dealing with consumers as well, I mean, obviously, if you've agreed to provide a million people with a particular item and you fail to provide any of them with it, that is potentially going to give rise to a big claim or a big refund claim. Typically, one individual, generally speaking, the result of not supplying to them isn't going to be catastrophic to your business. Whereas in a B2B contract, if you have one contract and you fail to perform, that could well be catastrophic, because the stakes with B2B are generally much higher. And the fourth point there, consumers may simply exercise their right to cancel and claim a refund, and also notify customers of possible delay. I mean, it's good, makes good business sense, doesn't it, to communicate with your customers and your clients to make sure that if there is going to be a delay to whatever you're going to do for them, you communicate with them, because generally speaking, if you set people's expectations, then they're going to be more likely to kind of go along with it when it happens, and hopefully less likely to bring a claim against you further down the line. So I'm just going to mention also potential or proposed changes to insolvency legislation. So there's not really much detail on this at the moment, and this is an area that Darwin Gray advises on. I do a bit of it. I have colleagues who do much more of it than me, but it is relevant to kind of corporate commercial law. Two areas where there's potentially changes coming up, but I don't think we've had the detail. We certainly had it a couple of days ago. Is wrongful trading and a new moratorium. So wrongful trading, I mean, in a nutshell, wrongful trading is where a business carries on to trade, and in doing so, basically incurs credit with third parties and exposes the creditors of the company in a position where the directors either knew or ought to have known that an insolvency was on the cards. It's not fraudulent trading. Fraudulent trading is a different thing. That's a criminal offence, which needs an element of fraud to it, whereas wrongful trading is where you knew or ought to have known that there was a pending insolvency, but you carried on anyway. And it is relevant at the moment to a lot of businesses, because a lot of businesses are in a situation where I think a lot of businesses, particularly the ones that haven't just gone off a cliff. So, you know, if you're a pub or a club or in the hospitality sector, then I guess you just ceased trading. You would have ceased trading a month or two ago. Whereas a lot of businesses probably, certainly in professional sectors, may not find they have problems until later in the year, because the knock-on effect of having 2 or 3 quiet months won't necessarily come through till maybe sort of the autumn time. But it is something to be careful of, and it's always a tricky balancing act between throwing in your hands in your hair and saying that's it, it's all over, which you could also be criticised for by chucking the towel in too early, but also carrying on regardless. And there are some proposed changes which will hopefully mean that there will be a period during which you won't get potentially that there won't be liability for wrongful trading. So we await the detail on that, but are this something hopefully that's coming down the track? Because the consequence of wrongful trading for directors particularly, and shadow directors, is that you can have personal liability. So if you've wrongfully traded for a period and you've basically incurred credit, and the creditor's position has got worse during that period, when you ought to have reasonably known that the company was going under, that basically you could be potentially liable for that extra liability that's been incurred during that period when you've been technically wrongfully trading. And also, it can also make things worse if you subsequently end up facing a director's disqualification proceedings. That can be also taken into account and end up with you being disqualified for a longer period. And you know, this is something that this is all going to come out in the wash further down the line. So it's something to be aware of, and there will be no doubt announcements about it. But that's one of the things. And then the other thing is a new moratorium. Haven't really got the detail on that. I mean, we have, for those of you that know about these things and maybe have had some experience of it, you can have administrations at the moment which do provide a moratorium during which you can basically seek to turn the fortunes of the business around, or more likely sell the assets, sell the business to going concern. But hopefully there's going to be a new moratorium period which will allow businesses to basically be frozen in time and not incur the wrath of their creditors, so it won't be possible to bring any claims around. So that's the second thing. It's very early days. We haven't really got the detail on that, but when we do get the detail, it'll be out on our social media. But just a couple of thoughts there, because I think it's worth having in mind the sort of insolvency aspect. It's a lot to think about, and there is a lot to think about at the moment. I mean, apart from worrying about whether your business is going to survive, you've all got to worry about, you know, at the moment, should you be carrying on trading? Should you be ceasing trading? And a lot of, you know, the insolvency practitioners are getting quite busy at the moment. I mean, I would say with insolvency practitioners generally, most of them are quite good when it comes to just having initial chats. So if anybody is worried about that kind of thing, then, you know, either I or one of the AGP people can no doubt put you in touch with somebody. So if you do have concerns about that, you can normally get on the phone to an IP and, you know, have a good old chat with them without incurring an initial liability. That's quite a good sort of thing that they do. But it's always worth having that, because they'll give you some good information. You'll have that, and you can make a note of it. And then further down the line, if there's any problems, you can go back to them. So the next thing I want to talk about briefly was insurance-related claims. There's, you know, I think there's been quite a bit in the press about insurers not doing the right thing, not surprisingly, when it comes to insurance claims, because people are trying to make insurance claims for this, that, and the other. There are various types of insurance policies out there, and I'm just going to sort of rattle through a few of them. I mean, one of them, you've got the traditional business interruption policies, which typically think back onto property-related policies. So if you have a physical damage part of if let's say it's physical damage to a property, then typically the business interruption element will kick in. So I guess that would work quite well in retail and manufacturing, where the business is tied to a property. So if you have maybe a loss of use, so that's one type of policy that you might have, that you might be able to claim on. And then you also get what's called contingent business interruption policies, which may relate to a particular situation. I remember fairly early on in this, people were talking about their insurers not paying out, and there were people on the radio and telly from the insurers associations saying, well, you know, all these policies have pandemic options, but a lot of people don't tick the box, because I suppose most people haven't experienced a pandemic, or not one in the UK anyway, not that's going to affect things in the way they are. So a lot of people found out early on that they couldn't rely on their policy because they hadn't bought that particular module. So, you know, I guess you've either got it, you haven't. I suspect that by now, if you are going to make an insurance claim, you've probably already made it, or at least you've started to think about making it. Although I have had clients coming to me where they haven't really sort of thought that through. It's always worth thinking about your insurance, because sometimes, as with home insurance, you can have modules of your insurance that you're not necessarily aware of. So you'll buy a particular policy, and there'll be little bolt-ons that you didn't think about. So it's always worth a look. Then you've got liability insurance, so potential claims from staff or public. I guess that's something that could happen depending on what you're doing and what happens, and those are probably going to be covered by your employees' liability or public liability. I think that pretty much most businesses are going to have that type of policy. And then lastly, then cancellation and abandonment insurance. So that will cover a particular type of situation with irrecoverable expenses and net profits, probably more relevant to the travel sector. So I think with all the insurance related stuff, I mean, you need to check policies, you need to speak to brokers, and you need to notify insurers. The key with insurance is to notify. I know people are quite often reluctant to do that because they think, oh, the premium will go up. But I mean, you need to have those conversations with the brokers, and you do need to notify, because the one thing you can be sure of with insurance is if you fail to notify and they've got an opportunity not to pay out, then they won't pay out, because they're going to be under the same levels of extreme pressure as everybody else. And you know, insurers generally, I don't think it's unfair to say, you know, they're not known for being sort of any more kind than they need to be. So if they can get an out, they will have an out. But you do need to have a look at those. So that's my whistle-stop tour through the topics that I said I was going to cover. Hopefully that's of some use to you. I'm quite happy to take some questions now, and hopefully I can answer them, or at least sort of shed a bit of light on things if anybody's got any thoughts arising.
Can I be first?
Please do.
Yeah. Sorry, just bear with me a second. Yeah, You can see me.
Yeah.
Supply chain.
Yeah.
Our supply chain, I know, are going to be under considerable pressure when we get back into business. We install sprinkler systems for residential and domestic. It's quite a specialized product that we buy, most of which is manufactured in the USA. We have talked to our main supplier about, let's call it bonded stock, if you like. We give them a list of stock, and they set it aside. Now, when I talked to people about this, they said, well, yeah, that's all very well, but it's a gentleman's agreement, and if you're under pressure from someone else, they may well let your stock go. And I just wonder if there's any way we could sort of tie something like that down, you know?
Well, I think you can, and it's a bit like the whole consignment stock situation, isn't it? I think you can tie it down legally, and if you have something, I mean, it may well be that if you've agreed something with them by email, that there is something that has got some legal teeth. But where are they based? Are they UK, or did you say they're overseas?
Well, they are. Yeah, they've got their distribution arm in the UK.
Yeah. So I think you probably can agree something with them. There's no reason why not. But it's a question of what they will agree to, isn't it? And what's going to be legally binding enough for you to do something about it. Because there's no reason. I mean, you can agree anything you like. So I think that's going to be a question of the particular wording that you put down and what they're prepared to agree to. And if they're prepared to commit to it, I mean, I don't see why, because it will literally, the legal position will literally depend on what you've agreed with them, and there will be a form of words that you can put together with them that will ensure that you're in the position you want to be in.
Well, at the moment, I think, well, possibly are protected them, because there have been an exchange of emails where they said, yes, we'll put this stock to one side for you and you can draw it down over a period. So
yeah, I mean, there's no reason why you can't have those arrangements. I suppose you need to look at the exact wording, because as they always say in the legal profession, the devil's in the detail in terms of what precisely the nature of the agreement is. And I guess you then need to think to yourself, well, what are you going to do if they renege on that? I guess if they renege on that, normal situation is you'd have to go somewhere else and get it. But then obviously you might not be able to do that, and then you'd have a claim against them. So that would be the sort of consequence of that, wouldn't it? But I think it's fair to say that if you've made a loose arrangement with somebody, then it is a gentleman's agreement and not enforceable. But if you've made a properly documented legal agreement with somebody, then it's going to be enforceable. And the idea of that really is that they won't then breach. They're not. You don't want to have to start suing them after. You just want the stock, don't you?
I don't think they will break it, but I was just curious as to the legal position. Okay, thank you.
I don't think there's any reason why you can't have an agreement like that at all.
Okay, thank you very much.
Anyone else with any questions want to come off your microphones? It's all very quiet out there this morning.
I must have covered it very thoroughly, Lisa.
Awesome presenting. That's all that can be said.
Must be that.
I was interested about business interruption cover.
Yeah.
And the fact that it has to be linked to a physical event, the broker was saying.
I think depending on what type of policy you've got.
Yeah.
I think if you have the kind of policy, because I think generally speaking, insurance, I mean, I'm not an insurance expert, but I do advise clients generally on insurance type stuff. I think if you've got the kind of policy that is attached to, like I said earlier, a property policy, then I think that kind of insurance has to be linked to an event, and the event then would be the property damage. But if you have business interruption insurance, which specifically covers pandemic, then that's you over the first hurdle, isn't it?
Yeah, the cover doesn't cover pandemic. That was an additional which we didn't take out.
Yeah.
What the cover did cover was the if something happened to our two biggest customers.
Right. Okay.
So in this case, our two biggest customers have ceased trading.
Right.
And as a business, we've ceased trading 100%. We're in the hospitality area.
Yeah.
Let's say the two biggest customers are not trading. They're listed in the policy that if something happened to them, from a business interruption point of view, but the broker is basically saying that it's a physical event. So if our factory caught on fire, or if their premises caught on fire, we could claim, but we can't claim as it is, in that there's no physical.
Right. I mean, the one thing about insurers you can rely on them for is producing lots and lots and lots of legalese, isn't it? And there'll be numerous pages and policies to flick through, which will, it'll have generally has all the answers in, and they are difficult to read, these things. I mean, even as somebody who's been practicing law for over 25 years, you get some of these policies, and they're written in what can be best described as a gobbledygook a lot of the time, and that's why you have the broker there to explain, I guess, on the front end and say, well, these are the options open to you. I mean, like you said at the beginning there about the sort of pandemic bit of the policy. I mean, I remember there was a lot of nurseries were getting publicity, a month and a half ago, because they were in the news, and a lot of them didn't have the relevant bit of the cover, because I think the insurance industry were taking a hammering, a couple of months ago, because all these nurseries were trying to make claims because people were pulling the kids out of them, and everybody was having a pop at the insurers, and the insurance associations were coming on saying, well, look, the policies are there, it's just a lot of people haven't taken that bit out, because it's risk, isn't it, at the end of the day? I mean, you don't want to spend all your money on insurance, so you take a calculated risk. And I think, to be fair, if everybody was asked to do that again, you'd probably do the same thing as you did before, wouldn't you? I mean, you would, if you rewound the clock 3 months and nobody knew that this was going to happen, why would anybody think this was going to happen? It was just beyond the contemplation of anybody, isn't it? So I think it's just one of these things. You've either, if you're lucky enough to have ticked the right box and spent a bit more money, great. But it's just not it's not the case. It's a bit like flooding, isn't it? I mean, 20 years ago, everybody thought that flooding a lot of the time was a 100-year event, but I don't think anybody believes that anymore, the 100-year event, do they? I think, well, it could happen. If a property could flood, it might well flood, and that's the way you've got to look at it.
Yeah. Okay. Good. Thank you.
No problem.
Me again. I think one thing that's come out of this is this may be an obvious statement, but it's the importance of contracts. We act as obviously subcontractors to major construction companies, or very large companies, multi-billion-pound companies. And I must admit, a contract comes in, it's a brief glance over it, it's signed and sent back, because you assume that there's no possibility of renegotiating any parts of that contract anyway. And I just wonder what your views are on that. When would you see a possibility of any renegotiation of these contracts, or do you think they've probably got it pretty much sewn up the way it should be?
An existing contract, or if you had a new one in that was a...
Well, the process is we'll put a tender in, they'll accept the tender, and then they'll issue a contract, very, very often tied up with the JCT contracts, in the construction industry.
Yeah.
But I just know that people like ourselves, we just accept those contracts, we sign them. I am certainly, in the light of the pandemic, it will be something I'll be looking at now, I think, a bit more closely, in case they've got something that they could throw back at us in the future.
I mean, it's an interesting point, because I mean, we one of the things we do for some of our clients is we do contract reviews. So, exactly like you say, they'll get a contract in from generally somebody that's much bigger than them, and it'll be some hugely lengthy document. And generally speaking, they've been working on that particular opportunity for some time now. The sales guy desperate to get it signed because they just want to get the order over the line so they can get their commission, and everybody just signs on the dotted. But what we find, I mean, it sounds like a bit of a sales pitch, but for a relatively small sum compared to the value of some of these contracts, you can get somebody like us to give it a light touch once over. I mean, you don't want war and peace. You don't want like a red line markup back that's going to take months and months and months to negotiate, particularly when, as you say, they may just come back and say, no, we're not having that. But a light touch review from somebody who understands these things is worth its weight in gold, because you're paying a very modest sum for that. And you'd be surprised that even with the very big players, they will agree to things. Because even if you're not changing the commercial terms, because that's generally been agreed up front, you'll probably find that a lot of the time, the kind of contracts that come out will have all sorts of stuff in there that isn't actually correct. against the contract that you're doing. So there may be errors in there which you want to have corrected, and there may be particular peculiarities that you want to change for you. And you'd be surprised that they will amend these things. I mean, I remember doing some work for a client who was in the provision of oil and water filtration and submarines and boats. And so they were always involved in massive MOD contracts. And these are billions of dollars worth of, or pounds worth of business. And we did one job in relation to some nuclear something or other. And the MOD was saying that there were dozens of these contracts that got out the door. And they actually said, there's only two of the suppliers have actually negotiated and picked them up on things. And there was our client and the electronic weapons provider, and they would negotiate even like the MOD size, you know. So it's definitely worth doing it, because, as I say, the amount you've got to, as long as you get the right level of attention on it, you don't want War and Peace. You want somebody who's going to concentrate on things like liability, insurance, limitation of liability, certain key areas, and you'll find that there'll be things in there that need to be corrected because somebody hasn't looked at them properly, because you'll have the procurement department will just send these things out and maybe they're wrong. So it's definitely worth doing. And my experience is they will negotiate. They won't give you everything. They won't give you everything you want, but they will negotiate, particularly when there's things that are just incorrect.
Okay, thank you.
Anyone else with any questions or comments? Well, you can go and have a cup of coffee now, I think, Stephen. Yeah.
Well, thanks for listening, everybody. I hope that was helpful. Just a few insights.
Thank you, very much appreciate it.
Thanks everyone for coming. If you look out for the emails and get them back to me, that would be fab. But have a good day.
Thanks very much.
You too.
Thanks,
Thank
Stephen.
you.
Thanks for presenting for us as well. Thanks.